Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here with Jennifer Walrath and Doug Plass. And today we're going to talk about religious accommodations under Title VII. This topic is somewhat evolving in light of the fact that there was a recent Supreme Court case, Groff v. DeJoy, which impacted an employer's obligations under Title VII to provide religious accommodations. So we think it's very important that as employers move further into 2025, that they know and understand their obligations when it comes to requests for religious accommodations. One thing that makes this somewhat interesting is that not only is the law on religious accommodations somewhat in flux and evolving, but also is the law on LGBTQ plus protections. We know we had the Bostock United States Supreme Court case in 2020, which certainly provided clarification that many people had been waiting for many years. And that clarification was that under Title VII, it is unlawful to discriminate against someone on the basis of gender identity or sexual orientation. I raise that because it's possible you could have conflicts in the workplace where someone claims they don't want to comply with obligations under Bostock because of their religious beliefs. So there could, to some extent, be tensions between various legal obligations based on Title VII and our United States Supreme Court guidance. That's one reason we think this issue is an interesting one, is we think there could be, as cases go up interpreting these United States Supreme Court cases and with new factual patterns, there could be interesting scenarios that invoke the law as it relates to religious accommodations. So I'm going to turn this over first to Jennifer, who's going to do a bit of an overview on Title VII as it relates to religious accommodations. And then we're going to turn it over to Doug, who's going to talk about that United States Supreme Court case. And then I'm going to take us across the finish line as we explore some specific issues related to religious accommodations. So Jennifer, I'm handing it over to you.
Yes. So as Pam mentioned, we are focusing today on Title VII. Although I do want to mention that if you are, an employer here in Idaho and you have 5 or more employees, there also are religious-based protections under the Idaho Human Rights Act. So in general, like many other protected classes under Title VII, there's a prohibition on discriminating against someone, an employee, with respect to their compensation, terms, or conditions or privileges of employment because of their religion. And in addition, there also is an obligation to accommodate. And that is something that's a little bit unique to the protected class of religion under Title VII, and where we're going to be focusing our discussion today. So the obligation to accommodate, it would be articulated as an obligation to accommodate a sincerely held religious belief, practice, or observance that is conflicting with some job-related requirement that the employer has, unless it would impose an undue hardship. And there's a lot baked in there, but essentially, there's this question of a religious belief that's sincerely held. Is there a conflict with some, policy or protocol or requirement employers have? And then is there an accommodation that's available? And whatever that accommodation might be, does it impose an undue hardship on the employer? And it functions it looks a little bit like some of the accommodation analyses that some of you may be used to under like the ADA or now even under the PWFA. But it is a little different, and I would encourage all employers kind of practice pointer to, make sure that you understand the standard for religious accommodations in particular, because there are some nuances that make it a little bit different and unique to itself. Starting first, a little bit about, what is a sincerely held religious belief. It covers things like traditional organized religions, right? So things like Catholicism, Judaism, Islam, Hinduism. It could cover smaller sects of those religions, even if they don't have a particularly large following. And as an employer, just be aware that it also could include things that you are not especially aware of, right? So just because you haven't heard of something doesn't necessarily mean that it isn't a religion. Okay, so if you're an employer and someone has identified a sincerely held religious belief that conflicts with something at work, then there is this question of accommodation. Some common examples of this may be observing the Sabbath, and that might conflict with an expectation of working on the Sabbath. Requirements of for hair or beards. For example, a lot of Sikh men will maintain a beard, and sometimes that can conflict if you're like an EMS person. You have to wear certain respirators, and that can be very difficult when you have a full beard. Head coverings, needing time to pray during the workday. Certain holidays that may not be covered by, a typical holiday policy. Dress codes. If you want to decline certain company celebrations, for example, because they don't align with religious beliefs, things like that are all, relatively common examples of, instances where religious practice may conflict with some requirement at work. And I think, one of the things that I wanted to touch on too, as Pam mentioned and highlighted at the outset, is that at times there can be, especially right now, a tension between, requirements or expectations of accommodating religious beliefs and the Bostock decision that said there are protections for persons based on their sexual orientation and gender identity. And I just wanted to give an example of what that might look like. For example, if you're an employer and you have an anti-harassment and a discrimination policy that specifically provides protections based on gender identity, that arguably means that, other employees, if they are misgendering someone or using a different name than that person's preferred name, that employee might say, you are harassing me and violating Title VII. Now, on the flip side, someone else who is engaging in that conduct might say, but I have sincerely held religious beliefs where I do not recognize that someone has a gender that is different from the gender they were born with, and it contradicts my religious beliefs to say that I have to use someone's preferred name and preferred gender. I need an accommodation to not have to comply with your policy. And I think that's a very realistic possibility that could happen for employers, and it's a very difficult spot. And I don't have an easy answer for what to do in that situation, but I mention it because it is it can be a very difficult and challenging issue. And so it is something that, HR professionals, supervisors, and others within a workplace do need to be aware of it, kind of educated enough to recognize those tough issues when they arise, and that something does need to be done. And it will, I think in all instances, be a case-by-case analysis, to decide, what makes sense and what is compliant with the law. But definitely important to have someone handling these issues who knows when and how to escalate them and get them addressed appropriately. And with that, I think, I'm going to turn it over to Doug to talk a little bit more about the undue hardship piece of this. That used to be kind of where a lot of these issues were addressed because it used to be a bit easier to kind of say, well, that's just too difficult for us. And so we aren't going to accommodate and we don't have to. But I would say that's I'll say changed more recently, and Doug can talk more about that.
Thanks, Jennifer. So I'm going to talk about the Groff v. DeJoy case. This was decided in 2023. And this does deal with the obligation that employers have to accommodate sincerely held religious beliefs as long as they do not constitute an undue hardship for the business. So this Groff v. DeJoy is kind of overlaid on this 1977 case, which is Trans World Airlines v. Hardison, that established the rule for considering the burden on an employer in a particular religious accommodation request. So that case had language within it that courts interpreted as meaning that an undue hardship in the religious accommodation context means anything more than a de minimis cost to the employer. So de minimis means like really anything at all, anything you can measure. So anything quantifiable would be more than a de minimis cost. And that was the rule that courts used until Groff was decided. So Groff v. DeJoy dealt with the situation where an evangelical Christian letter carrier's job changed because the Postal Service started doing Sunday deliveries of Amazon packages. And working on Sunday conflicted with Groff's religiously based desire to have Sunday for rest and worship. When this first happened, he transferred to another rural post office that didn't do deliveries on Sunday. And then, of course, the world caught up with him and they started doing deliveries as well. And then USPS didn't ever give him a full exemption from Sunday work, but helped to find him coverage, allowed him to come and work in late on Sundays, helped him find other employees that could cover shifts for him. And this was a burden on the other employees. They had to cover his repeated absences. And eventually, he couldn't get them all covered and he faced some discipline. So he resigned and he filed a lawsuit. And the issue that made its way up to the Supreme Court was what was the standard for undue hardship? And going into this case was really interesting because pretty much everybody agreed that de minimis was probably not the right standard here. And the expectation was that the court might reconcile Title VII with the ADA because there's very similar language found within them both. So under the ADA, undue hardship means significant difficulty or expense. But the Supreme Court, doing what it does, did its own thing. It did reject this de minimis standard, but in doing so, it didn't overrule this Hardison case. Instead, it said that what that court actually meant was something else. And what the court said was that this ADA standard went a little bit too far. And what the prior court meant is that undue hardship is shown when the burden is substantial in the overall context of the employer's business. And that courts should consider all relevant factors, such as the accommodations at issue and the nature, size, and operating cost of an employer. And another interesting thing that the court said is that when it comes to impacts on other employees, such as those in this case, it said that coworker impact can constitute undue hardship, but only if that impact is tied back to the effects on the employer's business. And there was an important comment that the court made, which is coworker animosity toward religion is not undue hardship. And one of the reasons I bring that up is because I think that is relevant to what both Pam and Jennifer were talking about earlier. In the sexual orientation and gender identity context. Courts haven't said this yet, but it's certainly possible that a court might say animosity toward those things is not protectable under Title VII. So the court also said that when an employer establishes that there is a substantial burden, the employer has to consider other possible alternatives as well. So what is undue hardship? Is a substantial burden? Well, it's not just occasional overtime that other employees might have to do. It's probably not some increased administrative burdens. But what you have to do is you have to look at what the impact on the business is. So the impact on a business with 20 employees is likely to be very, very different from the impact on a business with 200 or 1,000 employees. So this has resulted in a change in the landscape, and now it's much more difficult for employers to claim undue hardship. So really, a lot of the battles have to do with other parts to Title VII.
Yeah. So I think the big takeaway here, if you're listening in, is that the law is in flux when it comes to religious accommodation, that there have been some changes. And if you don't have a religious accommodation policy, you should consider adding that to your handbook. That's something when we're updating handbooks, I would say frequently we see an employer without any policy addressing that. So you should have an accommodation policy, not just for the ADA, but for religious accommodation requests. You should make sure that supervisors who are the boots on the ground running into certain factual challenges with employees, make sure they know that this is the law and that religious accommodations need a specific protocol to be handled. So that is one of the big takeaways here. One more reason we like employment law is it's always evolving and changing. One more reason you absolutely need training and good policies. So I just wanted to tackle a couple of other interesting issues when it comes to religious accommodations. We've heard Doug talking about how it's now a little bit more difficult for employers to argue undue hardship as a reason for not granting a religious accommodation. And we're starting to see cases interpreting what accommodations look like following the Groff v. DeJoy case. And as many of you probably know and understand, the factual situations that could give rise to this are always changing and evolving. And what we're seeing now is a handful of cases giving a little bit of context to what this can look like. So from Doug's perspective, it's a little more difficult for employers now. I'm going to be a little bit of a devil's advocate here, though, and say not all is lost, because what we're seeing in these cases is that there is definitely a multi-part test that goes into place to see whether or not an employee can assert a religious accommodation, whether they're entitled to it, and whether the employer needs to provide one. And in COVID in particular, we saw a number of situations arise where employees did not want to get vaccinations and they asserted religious accommodation requests in order to avoid that. And looking at some of the recent cases coming out, what is clear from that is that in order for an employee to prove a religious accommodation claim, they need to show several different things. And one of those is they have to convey a religious nature that goes along with whatever belief they're asserting. So it has to be information provided that shows the religious nature of the belief. And not only that, but how that belief conflicts with whatever obligation the employer is imposing or whatever duty the employer is asking the employee to do. So it has to be the conveyance of the religious nature of their belief and how it conflicts with whatever it is they're saying they can't do because of their religion. So an employee has to convey that, and there are a handful of things that are not going to rise to a level that requires an accommodation, and a few things that courts are looking at when making that decision include political beliefs, Political beliefs in and of themselves are not going to fall into the bucket that would require a religious accommodation. Moral beliefs in and of themselves may not get an employee a religious accommodation. Ethical beliefs and personal beliefs, those are all the types of things that may not rise to a level that entitles an employee to a religious accommodation. So the big takeaway on this is that the law, again, it's evolving. Employers need to be aware of it. Employers, just like under the ADA, they need to have a point person who's learning this law, or, maybe instead you're calling your lawyer or calling your HR consultant or someone else if this type of issue comes up. But this issue, just like ADA accommodation issues, is going to be fact specific, and it's going to be a little bit on the complicated side to work through. And I feel like it's changing and evolving really, I think, quite rapidly. So those are things to keep your eye out for. I will say that the EEOC is putting out some guidance on this on the internet right now. There's several different EEOC documents that you can find if you search under EEOC and religious discrimination. There's a bulletin by the EEOC that gives a pretty broad overview of it. And then there's one that's a deeper dive that is like a 60-page document that tackles many, many different types of religious accommodation issues, religious discrimination issues. It's a little bit dated because it goes back to 2021. And so that new Supreme Court case would have come out after that. And I know there's been talk by the EEOC of updating it. But like many types of EEOC guidance, it's worth taking a look at if you have a question or a concern. One more resource you can use to help understand the law. So that's it for us today. Again, as always, training, policies, someone following the law, someone making sure they know and understand what to do if a situation arises, because this is definitely an issue that on some levels it's been around a long time, but in others we're seeing it come up in differing contexts just based on changing, issues in the world. So that's it today for Ground Rules. Thanks for joining us. Don't forget the training piece of this. Don't forget to check out our Law for Leaders virtual and in-person training and our book, the Law for Leaders book. That's the roadmap every leader needs to know to avoid claims and lawsuits. That's available on Amazon. And thanks for joining us today. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.